A Tiger Woods failed romance is back in the news and it's feeling like 2009 again. Actually, put away your golf clubs, ladies, because this situation is very different. Erica Herman is suing Tiger Woods to try to get out of the non-disclosure agreement that she signed back when they first started dating in 2017. What's most interesting about this case is the legal reasoning that Herman is trying to sue under, and we'll get into that in just a second. Hey, I'm Josh Stanford, I'm America's attorney. Lawyer up to learn the rules of the game, and in this case, the usually unfair rules of famous people and their NDAs. I love what Tiger Woods can do on a golf course, but off the course, well, he might not be able to keep his tour card. So why does Herman want to be let out of the NDA that Woods made her sign back in the day? This is kind of a complicated situation. It appears to stem from an initial lawsuit that Herman filed against the Jupiter Island Irrevocable Homestead Trust, a trust that is in charge of Woods' home where Herman has been living for the past 5 years. A trust that allegedly kicked Herman out of the residence in less than great circumstances. According to Herman's lawsuit, Tiger or his minions told Herman that she was gonna go on vacation and had her pack her things. And when she got to the airport, she was informed that the locks had been changed back at the house and that she was no longer welcome at the residence. Not cool. I mean, whatever happened to the good old-fashioned "it's not you, it's me" speech at the crowded restaurant? I mean, if those allegations are true, I'd say Tiger drove his ball right out of bounds. Anyways, this led to Herman to file suit against the trust. But due to the NDA that she signed back in 2017, which contained an arbitration provision, they are attempting to start an arbitration to keep the litigation out of the public eye. Now, I did an explanation about arbitration agreements in one of my recent Logan Paul videos, but here's a short recap. Arbitration is like pretend court, but with real court consequences. On its face, arbitration is supposed to be faster and somehow better than court, but there are strings attached. Every single time in the entire history of private arbitration, the party with more money is the party that insists on arbitration. It's always the party that stands to lose more if the public knows about its misdeeds or, alleged misdeeds. That's the one that wants to enforce arbitration. Arbitration proceedings are like court, except that they are secret, they are pretend and not real, and the party with more money is the one who pays the fake judge to decide who should win. Is any of this making any sense? In this instance, it's golf legend Tiger Woods who wants to enforce a secret proceeding in arbitration. Herman signed this NDA in August of 2017. She doesn't contest that she signed the agreement to arbitrate. You know what else happened in 2017? The beginning of the Me Too movement. And as we all remember, the Me Too movement was a widespread sharing of stories on social media from victims of SA and SH. I'm not gonna say the words that you just saw up on the screen in this video so as to not upset the YouTube gods, but that's what I mean when I say the letters SA and SH. Now, a lot of these stories took place in work environments, and in the years that followed, hundreds of accused men lost their jobs. This movement is actually a central piece of Herman's story for two reasons. Number one, the Me Too movement featured a lot of workplace stories. Guess what kind of relationship Herman and Woods had when the NDA was signed? Employer-employee. She was a manager at Woods' restaurant called the Woods Jupiter. The Me Too movement was critical in helping society realizing that the power imbalance between an employee and employer casts doubt about the actual level of consent that can be given by an employee. And number two, the Me Too movement started the conversations that led to the two laws that are giving Erica Herman a chance at escaping her NDA. So in order to have her original lawsuit go to a jury trial and also not be decided by an arbitrator paid by Tiger Woods, Herman needs to have her arbitration agreement and NDA invalidated. How can she do that? The second lawsuit that she filed claims that the NDA must be invalidated under the federal Ending Forced Arbitration of SA and SH Act of 2021 and the Speak Out Act of 2022. Let's break those acts down. The Ending Forced Arbitration of SA and SH Act of 2021 was signed into law on March 3rd, 2022. This act invalidates pre-dispute arbitration agreements or class action waivers with respect to cases that relate to an SA or SH dispute. What does this mean? An ARB agreement signed before SA or SH occurs or allegedly occurs is not enforceable once or if SA or SH happens. The second act that Herman and her lawyers are citing is the Speak Out Act of 2022. This act prevents the enforcement of NDAs in instances of SA and SH regardless of when those agreements were signed. Now, at this point, you might be a bit confused. Where's the SA claim coming from? All I've mentioned so far was a housing disagreement and a trip to the airport gone poorly. Well, according to the civil cover sheet filed by Herman's lawyer, the case involves allegations of SA. But before you start pointing fingers, no one, including Woods, has been specifically accused of anything. Maybe because of a certain NDA. We don't know yet. But Herman is very unambiguously pointing at the possibility with her recent filing. Where Herman's claim could potentially run into some trouble, however, is due to the factual findings that the Speak Out Act was based on. The findings that Congress specified as the basis for the need for the act were laser focused on workplace relationships. These findings include facts like 1 in 3 women has faced SH in the workplace during her career, and an estimated 87 to 94% of those who experience SH never file a formal complaint. And also, non-disclosure and non-disparagement provisions in agreements between employers and current, former, or prospective employees can perpetuate illegal conduct by silencing those who are survivors of illegal SH and SA and limiting the knowledge of that conduct while shielding the perpetrators and enabling them to continue their abuse. These findings could lead someone, Woods' attorneys, to try to make the argument that it doesn't apply to Herman and Woods' personal relationship. However, and despite those findings, which are codified in the law itself is far more expansive in its text, in the scope of the agreements that it invalidates, because the act on its face appears to extend well beyond the employment context that it talks about. But what if, just imagine, what if this issue came before a crotchety old judge who thinks the law is too broad and should be confined to the employment context identified in the finding sections of the act? I'm telling you, things like this do happen, and there actually are judges who would try to narrow a law like this that protects women and victims of abuse. But this still wouldn't work to rescue Woods' NDA, because as you know, if you were paying attention earlier, Herman was an employee of Woods at the time the NDA was signed. In other words, Woods had an imbalance of power in the relationship with Herman when they started dating, just like set forth in the act. Ugh! It's such a bad look for Woods. Either way you look at it, the law is going to apply. All that's left for Herman is to prove that an SA or SH claim that requires the NDA to be invalidated, and she's good to go. She doesn't have to win those claims. She just has to make them. So far, the attorneys for Woods' trust are clinging to an argument that a trust can't be sued because
they're not a juristic person.
That's going to lip out and roll off the green in my view. The trust owns property, then it has rights. And if it has rights, it can sue to enforce them. And if it can sue to enforce rights, then it can also be sued for abridging the rights of others. Regardless, the courts will have to make a decision on the enforceability of the NDA. Erica Herman is the first person to make the news for suing under these two acts since they were made law, and it's going to be very interesting to see how these things play out. But what are your thoughts on the lawsuits based on what you know so far? Should Herman's NDA be ruled invalid? Do you think this will affect how celebrities set up their NDAs in the future? I want to know your pro se opinion, so let me know in the comments down below. Make sure you subscribe to the channel and check out my videos on these sports celebrities and their legal troubles, because I'll be back soon with more videos. Bye.